I guess the first issue is how much attorney fees it's gonna pay.
Thank you.
D 13489676C, and I apologize, but it's not my cause of the problem, but I apologize for the delay.
It's okay.
So how do we do?
Good afternoon, Your Honor. Christopher Tillman, 5150. They came up with a partial plan. There still is a question and a debate as to what the actual timeshare should be. I mean, they had a tentative agreement, but my client doesn't feel that may be the best agreement going forward, so they could not come up with a primary custodian and an actual timeshare. But everything else is agreed to.
I don't know if this is right or wrong. My law clerk says basically we're fighting over 30 minutes.
No.
I mean, my client's willing to allow the plaintiff, we will acquiesce to the timeshare set forth in the complaint. I mean, at this point, I've really tried to keep this uncontested. These parties should not be fighting over 30 minutes. They've been doing exactly the timeshare in the plaintiff's complaint since October, except they've been doing the exchange at 9 a.m. rather than 8:30. But to resolve it, my client is willing to do the 8:30 exchange. It's not a problem. I mean, at this point, I'm not really sure what the plaintiff's position is.
You're nodding your head.
I don't know what she's talking about. That's
Talking
not.
about in Annetta's complaint?
In the amended complaint filed January 14th, 2014, it says the plaintiff, so that would be your.
I don't have a problem with 8:30. That's not what we're.
Shall have the child beginning Sunday at 8:30 to Wednesday at 8:30, and defendant shall have the minor child Wednesday at 8:30 to Sunday at 8:30. Parties shall alternate Wednesdays. The parties agreed about the exchange and the parenting agreement, so I don't know why. That's what they've been doing for 9 months now. So we are willing to concede on that issue.
So what is the problem? You got a problem? What-
Well, Your Honor, that amended complaint was filed way long ago, and things have changed.
She says there's no dispute. You say there may be a dispute. So what is it?
The dispute is the actual time available with the child. And that comes down to on the Wednesdays and the Thursdays, because he has alternating Wednesday,
Yeah.
according to what they're saying, there's been a lot of use of daycare when my client's available. Now, the good news is, Your Honor, they do have a right of first refusal, a 3-hour right of first refusal in the partial parenting plan. The problem is that really hasn't been adhered to, except for a few times, like last Saturday, was it?
This past
It was,
Saturday.
it was adhered to. Maybe because they had already come to an agreement in mediation on that issue. But what Marcy's telling me is that if we look at, and I haven't had a chance to go through all of the times that the child's been in daycare on dad's time, it's going to turn out to be a primary custody to mom case pursuant to Rivero and Rivero 2. So that's the real main event, is actual time with the child and availability.
Okay.
Right, because the law supports punishing a parent for working. Ms. Wells also has a job and has also utilized the same daycare that my client utilizes. In fact, it was his daycare benefits through MGM. Parents work. They both work the same job for a number of years now, and this is what they came up with back in October when they split up. My client shouldn't be punished. He will absolutely abide by this court order, and they just finalized the terms of this parenting agreement a couple weeks ago, or within the last, I would say, even 10 days. So my client has abided by it, fully intends on abiding by it. But Ms. Wells is eventually, just because she's cut back her hours for the purposes of this litigation, doesn't mean that she's always going to be unemployed. She just got her bachelor's degree. She's working on her master's degree. I mean, this isn't a situation where my client is just taking the time to have the joint physical custody status. These parties have raised this child together and decided in October to share time equally. So why we're setting it for trial when they've already made this decision in the best interest of their child would be, I don't understand. The complaint is very clear. We'll concede. to her complaint?
Because, and this is why, of course, retained jurisdiction over custody matters, because things change in the lives of children. And so, yeah, it may have been great in October when she was working more. You know, she's not cutting back hours because of purposes of litigation. It's because her life is changing and the child's life is changing. So, you know, I mean, if he's not available on those Wednesdays and Thursdays, then the child should be with mom. That's all we're saying is availability. I mean, a lot of times, Your Honor, as you know, and I think I've heard it come out of your mouth, it's not about him being terrible dad and my client being super mom. A lot of times it's about who's available to raise this child. And, you know, and I haven't had a chance to give them to Holly, and I haven't had a chance to really look at them, but there are some times that child's in daycare for 10-hour stretches. Mom's available on those times. Now, we're gonna have to retroactively go back and show Your Honor that she was available.
Well, I guess right now we're just deciding whether we need a trial, and I guess the answer right now is yes. Obviously, I'm gonna have to look at the arrangement. If it's a joint physical custody right now, time-wise, you're gonna have to prove why you want it changed.
I understand, and I've let Marcy know that it's a trial issue, and she
I
understands
both
that.
parents have to work, and I think Rivero takes that into consideration, whether it's his time is his time, or her time is her time. For the most part, obviously, the other thing is, I think the Supreme Court, even though it did not express it, obviously, if I give him 4 days and he can't use 4 days because he's working, he can obviously use daycare some of the time, but if he's going to use daycare most of the time and it's just not working because he's not taking actual care of the child.
I don't, but I don't mean.
If you can prove that, then you'll be able to prevail. Otherwise,
No, and I understand, but I don't.
Each party has the freedom to use some daycare here and there.
Usually, when we don't have what we have now, though, Your Honor, now they've agreed, they've both signed a 3-hour right of first refusal.
Okay.
So at this point, from this day forward, if you make this an order today, then, you know, he's got to pick up the horn and call Marcy before he puts her in daycare. She's got to afford him the same
I'm going to
person.
need a final order from you two as to what the actual parenting arrangement is, because this doesn't say it. It says they desire the court to make the final determination in this matter for them. So if you two can agree, give me an order. If you can't agree, give me a phone call and we'll set a trial date.
Well, they don't have an agreement as to actual timeshare, except for what Holly was mentioning. They have this verbal agreement, and they have what my client's prior counsel.
Conceding something, so if there's an agreement as to what time he wants and what time she's willing to give, put it in black and white, and I'll sign it.
Holly, I don't think we have an agreement in that
Judge,
regard.
she pleaded very specifically about what she wanted.
Right.
We are allowing her to take that. That's what she wants. That's what she gets. 8:30. My client gets 8:30 on Wednesday to 8:30 on Sunday, week 1. 8:30 on Thursday.
It says the plaintiff should have the minor child beginning Sunday at 8:30 to Wednesday at 8:30.
Right.
And defendant should have the minor child beginning Wednesday at 8:30 to Sunday at 8:30 a.m. And the party shall alternate Wednesdays.
Right, so it's a 4-3-3-4 split. That's what was pled.
We can see.
Here's and again, I'm just trying to maybe save us all some
The
heartache.
biggest problem I'm trying to have is there a dispute or not?
There is.
Okay.
There's a dispute as to whether that is in the best interest of the child from now. That pleading is 5 months old. So if you make it an order today, a final order, then I guess we'll just have to file a motion to change when
Well,
we
I'm
see
going
the child's
to
not
make it an order today, and I'll set it for trial if you want to change it.
make it a temporary order and set it
Because
for
this is
trial.
what you wanted, and they're saying yes, okay. Now she's saying no, it doesn't work. And this complaint was filed,
The amended was in
January.
January, right, with her prior counsel.
so 5 months ago,
And they were doing it 3 months before that. They were doing
and
it.
they're still doing it.
Right, except they're doing exchanges at 9. But if she wants 8:30, that's fine. We'll do exchange at 8:30 instead.
So right now, on this temporary order, if you wanna go to trial on it, what time do you want? Sunday at 8:30 AM or Sunday at 9? 9? Sunday at 9 AM to Wednesday at 9 AM?
It's a week 1, week 2, yeah.
And defendant will have the child then Wednesday at 9 AM to Sunday at 9 AM. And the parties are gonna alternate Wednesdays. So whose Wednesday is it this week?
This coming Wednesday will be mine
Okay.
in 2 days.
And you're gonna exchange still at Wendy's?
No, it is at the Arco gas station at the corner of Flamingo and Jones.
You're still good with that?
That is in the parenting agreement.
Okay.
Oh, that's right, it's in the parent agreement.
So the exchange will be at the location in the parenting agreement. I've signed the parenting agreement. So everything's been ordered and taken care of except, apparently the plaintiff would like some changes made. We do have a right of first refusal of 3 hours, so I'll let the attorneys discuss it and see if they still need a trial. They'll contact my office and we'll do a trial setting. I still don't know what the trial will be about.
Well, it'll be about availability, Your Honor.
About his availability.
Correct.
Okay.
Correct, and like I said, I mean,
Well, that's a good point. I mean, if you think he's getting a lot of time with the child that he's not around, then we'll have a trial and we'll see if that's true.
well, from what I've seen, you know, there has been, and I take issue with what Holly said about my client utilizing the daycare a lot. I mean, you know, 90% of the
I
day.
did not say a lot, I
The-
said
not-
she's also utilized.
Yeah, well, a few times, but 95% of it is, you know, dad putting the child in daycare, and we're gonna have to go back and recreate dates, but Marcy's telling me that she's physically available, sitting around, not working, and the kid's in daycare for 10
This
hours.
is a change that happened since January?
Correct.
Because she's voluntarily reduced her hours, so now she's not working as much as she used to, but she's also in a master's program, so she's going to school, so maybe she is available more than she was before, but there wasn't any change on my client's part. He didn't start working more because he had the child. So it would be a change from her end,
But that's not the standard.
not,
I
sure.
mean, the standard right
And
now is
that's
best
why-
interest.
And that's why they agreed to a right of first refusal, Your Honor, because she wanted to make the child to be with her if she was available.
Well, how much time does she want that she thinks he's overusing the daycare? Is it a couple hours? Is it a couple days?
No, there's at least 8 hours to 10 hours on those Wednesdays, Thursdays, and sometimes Fridays when she's available. That's the point that Marcy's making, is why should the child be in that daycare when she's available on his days? Now, some of those days that the child's in daycare on her time there's one that was like 3 hours. She had to put her in the daycare for 3 hours.
I'm just trying to figure out if this time change is gonna change it from a joint physical to a primary physical.
Well, I think that's what I said. Under Rivero, I think he's gonna be under that magic 70 or 69.5 hours or whatever it is for the week when you add it all up. If in fact, you know, we cut the Wednesday and the Thursday from him. And that's, you know, and again, what I'm not saying is he shouldn't see his
He's always
child.
off Wednesdays and Thursdays, so I don't know how, he's almost always off Wednesdays and Thursdays.
Well, it depends on, you know, he has
Let me know
3 different
by
jobs,
Friday-
so, I mean.
Let me know by Friday if there's a final agreement or you want a trial date on the timeshare.
Okay, should I just do a letter and CC, obviously, Holly on it, or do you want a phone call?
Well, I think it's the ball's in your court, so you need to do a fax to her and to me that you wanna have a trial. on
Okay,
this issue.
all right.
Cause they're willing
You're okay
to,
with getting a fax, right?
they're willing to accept this
Well, I mean-
agreement.
You want an email?
No, that's fine. A fax or an email. So
Okay.
I just. This is my concern, Your Honor, is they go to mediation, they agree that they both should utilize the right of first refusal, and now what Mr. Tillman is saying is that if my client turns the child over to her during the hours that he has to work, they're gonna use that against him at trial. So it's a right of first refusal, it's not her time, but if he utilizes the right of first refusal.
Well, you bring up an interesting
Yeah.
point, because that will complicate the matter now. Is there a right of first refusal, and is there gonna be a sword you're gonna use?
Well, I don't see it as a sword. I mean, what Holly's saying is, if you sift through, is the kid's better off in daycare than with mom.
No, that's not what I'm saying. What I'm saying is that, so when she goes back to work, then we're gonna be back in here, we're gonna be like, oh, by the way, now dad has more time because now she's working a
Well,
job.
I agree with what you're saying, and mom's gonna have to figure that out, because, you know, if she says, well, dad's working these hours and I want this, and then when she goes back to work, we're gonna have the same rules for her. And she'll have to look at that. That's why I'm giving you both time to cool down and think about what you are asking for, because it's gonna cut both ways. And if this is just a temporary arrangement, and you're gonna have these short hours until you finish your school, and then you're gonna go back to school, then we're gonna come right back, and then we're gonna have to litigate this again, because now you're gonna be working more hours, and then we're both gonna be using daycare, and then we may have to change everything. And I don't know how long this arrangement's gonna work, because I don't know if you're gonna go to school full-time, how many more years. This is just a short time, you're taking some more classes, I don't know all that, but I'm giving you both times to cool down and think about it. They're okay with the arrangement that is, you're the ones not okay with it. Even though they gave you what you wanted in January. And now you don't want that, so we'll discuss it, and you discuss it with your attorney, and we'll set it down for trial if we have to. You can contact me between now and next Monday and let me know.
Oh, I have till the 30th?
Yeah.
Okay, that actually is preferred. Thank you, Your Honor. So I'll just do a joint letter and email it over to Holly if we decide to go that route.
Okay.
Okay, so Holly, you'll prepare and incorporate
Yes.
this today? Okay, great. Thank you very much.
And then I'll issue, if you do want a trial, I'll issue a
How far out are these?
jury trial, and it's looking like November, December.
Okay, very good.
Okay,
Thank you, Your Honor.
thank you, Your Honor.
And I signed the parenting agreement, so that will be the order, correct?
Yeah, we have a copy, and
Yes.
Holly is gonna
Thank you.
incorporate it into the
I will.
order that she
Yeah,
has.
whatever you decide, I need a temporary order to cover what we have agreed on today.
I will do that.
Understood.
I will prepare that.
Thank you,
Your
Your
Honor.
Honor.